Good morning, everyone. I'm gonna do this is probably gonna be a little bit of a longer video actually, because I've got 3 filings to get through. So I'm trying to catch up with everything because today is the day that Blake Lively has to respond to both the motion for summary judgment and the motion for judgment on the pleadings. So I want to get caught up so I can concentrate on that because we've got quite a lot coming. We've also got on Monday, both Lively and Jones Works. I've got a reply to Wayfarer's opposition to their motions for spoliation sanctions. So there's quite a lot to do. I'm also going to be doing, once I've got some of these filings out of the way, assuming that nothing else gets unsealed and nothing else drops, I want to go through, just do like maybe one episode where I'm going to read the whole 250-page court filing complaint against Candace Owens by President Macron and his wife Brigitte. So I read it last night. It was absolutely fascinating. I'm not going to be taking an opinion or anything, just like go through it because it's a really nice, easy to read document, but it is 250 pages long. So I'm going to do that as like a separate standalone thing when I've not got something going on with this kind of multitude of cases. So I'm going to start with Popcorn Planet. They were subpoenaed along with, a lot of other content creators, including myself. Their subpoena was the only one still standing, and they had filed a motion to quash. Last night, an order come in on that motion to quash, and it was denied. It was a particularly disappointing ruling, in my opinion. So I was just going to read through the order, like for the rationale. I'm not going to weigh in on that either. Andy's a friend. I'm disappointed. Everyone else's subpoena was withdrawn by Blake Lively, so this is particularly frustrating. But I've said several times in videos, I can see why Blake Lively is pushing harder here because he has a documentary. Because he has, he's Andy himself has said that he's spoken to crew members, etc., for that documentary. So I can see that she would want to be pushing for that potentially. I don't know the ins and outs of what's been asked for, but in my mind, I could see more logic with why she's trying to get discovery from Andy than she could from any of us, really. So I'm going to read this. I think someone mentioned that Andy briefly covered this on his live last night about Jada. And there he commented that he wasn't concerned, which is fantastic, and that he does intend to appeal. So, I will be looking forward to seeing how that goes. And I wish him all the best with that. But I do want to just read through this. So I'm going to get, as usual, just to save time as well, I'm going to just skip over the parts that are the actual legal standard and case citations. So under Rule 45D3, Federal Rules of Civil Procedure, Popcorn Planet moves to quash a subpoena for documents served by Blake Lively, who responds in opposition. I have not covered the rest of Andy's filings, the various filings that have come back and forth on this, because obviously Andy has his own channel to do that. So this is the only thing I'm going to cover on it, unless it goes to an appeal. Because Popcorn Planet fails to establish that the privilege applies or otherwise waive that privilege and fails to demonstrate an undue burden, the amended motion to quash is denied. Okay. So, background. The matter relates to Lively v. Wayfarer, etc. Lively sued in December 2024 and alleged that during production of the film It Ends With Us, she experienced sexual harassment and an organised campaign of retaliation led by her co-star Justin Baldoni. According to the complaint, Baldoni engaged crisis manager Melissa Nathan to help Baldoni get ahead of the narrative and mitigate bad press generated by Lively's complaints. The strategy allegedly included third-party advocates willing to provide a potential quote or engage with reporters on behalf of Baldoni and others, and the seeding of content on traditional and social media platforms. In an amended pleading, Lively alleges that this campaign continued after the filing of her complaint. According to Lively, the defendants directly engaged with media platforms to overwhelm and confuse the public's understanding of Miss Lively's allegations and to drive negative sentiment against Miss Lively and anyone who supports her or speaks out against Mr. Baldoni. I mean, there was no attempt to overwhelm and confuse the public or their understanding of her allegations. We still haven't seen evidence of them. In fact, we've seen evidence to the contrary. Lively further alleges that this campaign involves statements by the defendant's lawyer, Brian Friedman, who regularly issues inflammatory content to media outlets and who says anything, whether true or false, that will harm Miss Lively's credibility and intimidate others from speaking. This is annoying because the only person who has attempted to intimidate people from speaking is Blake Lively when she, subpoenaed 100 and odd content creators. Lively alleges that Mr. Friedman's statements were published with actual malice because the defendants knew that the core narrative advanced by Mr. Friedman, that Miss Lively fabricated, made-up sexual harassment claims to seize control of the film, is false. In my opinion, it's not. The defendants allegedly seeded social media content with content creators and online chat sites like Reddit and into publications with small audiences and lax editorial standards. The team would then amplify that content by sharing them with larger publications. Among her claims, Lively alleges defamation and defamation per se by Baldoni and others through their agents, including Brian Friedman, based on their publishing false and defamatory statements about Lively. Andy Signal is the founder and CEO of Popcorn Planet, which he describes as a publicly accessible news and commentary channel with nearly 1 million subscribers and a large daily viewership hosted on Popcorn Planet's designated YouTube channel. Signal describes himself as Popcorn Planet's main host, investigative reporter, and paid employee. Signal claims extensive experience in journalism and entertainment news reporting. Lively subpoenaed Popcorn Planet for 7 categories of information related to the underlying action. The subpoena called for a response by July 23rd, 2025. On July 25th, Signal moved to quash the subpoena, which he followed with an amended motion to quash on July 29th. In the amended motion to quash, Popcorn Planet argues that the subpoena seeks material covered by the journalist's privilege, that Lively cannot overcome the privilege, and that the subpoena imposes an undue burden because Lively could obtain the documents from the defendants. Lively responds that the subpoena does not seek privileged material, that even if it does, Lively can overcome the privilege, and the subpoena imposes no undue burden. Okay. So let's go past this. Right. So, firstly, Popcorn Planet fails to show that the journalist privilege applies and otherwise waives its claim of privilege. Signal formed Popcorn Planet on June 20th, 2022 as a Florida for-profit corporation for the purpose of media production. He reinstated the corporation on October 8th, 2025 after an administrative dissolution in 2024. Signal claims that he is an investigative reporter and receives a salary from Popcorn Planet. Signal describes Popcorn Planet as a publicly accessible news and commentary channel and himself as the show's main host. Popcorn Planet's channel is an account on the website youtube.com through which Signal publishes content. Signal describes the channel's content as news videos, some of which feature legal experts to comment on high-profile court cases involving celebrities. Signal claims that he is unquestionably entitled to invoke Section 5015 Florida statutes, as well as the common law federal privilege. Signal asserts that Florida courts have already determined that the statutory journalist privilege applies to internet-based entities as long as they report the news. However, none of the cases cited by Signal determines as much or contains significant analysis of the statutory language. Similarly, Signal claims that he is a professional journalist as defined in Section 90.5015, but again offers no analysis of the statutory language and concludes without explanation that Popcorn Planet satisfies that language. Finally, Signal claims that the content published by Popcorn Planet constitutes news because that content is information of public concern, namely in the categories of entertainment, culture, and current events. To qualify as a professional journalist, Signal must regularly engage in the collection and publication of news while working as a salaried employee or independent contractor for a newspaper, news journal, news agency, press association, wire service, radio or television station, network or news magazine. Yet, Signal says nothing about how Popcorn Planet fits within the meaning of these terms. For example, Popcorn Planet concludes that without analysis that Popcorn Planet is the type of employer contemplated by this section. However, a YouTube channel such as Popcorn Planet is clearly not a newspaper or news magazine under a plain and ordinary meaning of those terms. Neither does Popcorn Planet readily fit the terms news agency, press association, wire service, radio or television station, or network. That leaves news journal, which appears to exclude from its plain and ordinary meaning a YouTube channel. Even if Popcorn Planet could muster a definition broad enough to cover its YouTube channel, any interpretation must consider the context in which the term appears. Section is precise and clearly intended to exclude certain types of media, as evidenced by the exclusion of book authors and others who are not professional journalists. The definition of professional journalist includes within its scope professional news organizations, which are distinguished in part by the exercise of editorial standards and control. Nothing submitted by Popcorn Planet suggests that its show practices the editorial standards normally associated with a professional news organization. Furthermore, although Signal investigates entertainment news and creates content, his position at Popcorn Planet is not the type contemplated in Section 90.5015. Signal says that he's employed by and receives a salary from Popcorn Planet, but he is also Popcorn Planet's owner, founder, and CEO, the host, director, editor, and main producer, as well as the registered agent of the company, the addresses for which consist of a USPS mailbox and a private residence, according to the Florida Department of State. Thus, Signor is self-employed, and Florida courts have historically held that the journalist privilege applies to journalists employed or hired by traditional media outlets. Additionally, as explained during the first hearing on Popcorn Planet's motion, whether the privilege applies depends not only on whether Signal is employed as a professional journalist, but also whether he was engaged in news gathering at the time that he obtained the information. Even if Signal is employed as a professional journalist within the meaning of the privilege, Signal is not necessarily engaged at all times in professional news gathering, in the same way that a lawyer is not always engaging in attorney-client communication or working in anticipation of litigation. Signal cannot assert a blanket claim of privilege over his activities, but rather must assert that privilege on a document-by-document or item-by-item basis, as would any other holder of a constitutional or statutory privilege. Furthermore, Rules 26 and 45 require a timely and express claim, as well as a disclosure of information sufficient to support his claim. Here, Lively served the subpoena on July 3rd, and Popcorn Planet moved to quash on July 25th, 2 days after the time required for compliance. As of October 22nd, Popcorn Planet had not produced a privilege log identifying responsive but privileged documents, and had not sought an extension of time in which to do so. After requiring the parties to confer about the scope of the search for responsive documents on October 31st, 2024. After requiring the parties to confer about the scope of the search for responsive documents, an October 31st order. It says October 31st, 2024, but I think that's a typo. Required Popcorn Planet to produce a privilege log no later than November 5th. Popcorn Planet moved for an extension of time and attached a preliminary privilege log to its motion. During a November 7th status conference, I explained to Popcorn Planet that the privilege log was inadequate. For example, in one entry, the log identifies a text string spanning from January 1st, 2025 to June 24th, 2025. The description, that entry, along with every other entry, is a vague, conclusory statement, essentially saying that the item is privileged, which provides little basis from which to evaluate the claim of privilege. In response, counsel for Popcorn Planet argued that it was nonsense or absurd to suggest that he had to log or itemize each and every text message subject to the privilege. Consistent with counsel's position that the law does not require particularity and that Popcorn Planet can claim the privilege categorically, the final privilege log filed by Popcorn Planet contains no changes except for the addition of 2 items. Counsel for Popcorn Planet is incorrect on the law, and he fails to show that the subpoenaed communications were privileged. Popcorn Planet produced no privilege log until ordered to do so 3 months after receiving service of the subpoena. Thus, Popcorn Planet failed to timely provide a privilege log, and despite repeated opportunities to correct this omission, Popcorn Planet failed to produce a privilege log with sufficient particularity to assess the privilege claim. This results in a waiver of the privilege. Okay. An in-camera review of documents included in the privilege log demonstrates the problem with Popcorn Planet's generic and conclusory privilege log. For example, item 4 on the privilege log is a 6-month-long, 89-page text message conversation between Signal and a defendant in the underlying lawsuit. So that would be a defendant from the main Lively v. Wayfarer lawsuit. It does not say who that is. As one would expect, the conversation contains some information that is clearly irrelevant, unresponsive, and not privileged. The text message conversation constitutes the bulk of the material in the initial privilege log, which contains a mere 142 pages. Yet the log nowhere specifies the number of individual messages, pages, or specific exchanges to which the privilege allegedly applies. The final privilege log contains only 2 additional items, which suggests that the final universe of documents is not much longer than 142 pages. Thus, Popcorn Planet cannot plausibly claim an undue burden in having to separate these documents into their relevant and purportedly privileged parts. Even if the inadequate privilege log caused no waiver, Popcorn Planet's production of documents has. A comparison of documents included in the in-camera inspection with those produced to Lively reveals no discernible substantive difference. Items 5 through 17 and 19 are inquiries by individuals associated with Popcorn Planet seeking comment from people involved in the film who provided no substantive response. These emails are similar in content and character to the emails produced by Popcorn Planet to Lively. Yet Popcorn Planet provides no information about why some inquiries are privileged and other similar inquiries are not. Accordingly, I find that Popcorn Planet fails to establish that the items responsive to the subpoena are protected from disclosure under the journalist's privilege. Even if Popcorn Planet established the privilege applies, Lively overcomes it. Even if Popcorn Planet established that the items sought by Lively fall within the journalist's privilege, Lively can overcome it. The requests in Lively's subpoena are directly relevant and material to her claim that the defendants in the underlying action orchestrated a campaign to defame her with the help of third parties who created disparaging and false content. Furthermore, an in-camera review reveals that the responsive materials are directly relevant and material to Lively's claim. You keep spelling Lively's name wrong. Lively further establishes that she tried to discover this information from the defendants and, to some extent, has been unable to obtain those messages from them. Lively demonstrates a compelling need because these materials go to the heart of the matter. That is, the primary theory underlying Lively's defamation claim. The subpoena imposes no undue burden on Popcorn Planet. Popcorn Planet argues that the subpoena imposes an undue burden because the subpoena seeks extensive document production and because Lively has not exhausted more direct avenues to obtain the requested information. This argument fails for several reasons. During the first hearing on Popcorn Planet's motion to quash, counsel admitted having not discussed the scope of the request or the attendant search with counsel for Lively. When given an opportunity to raise objections to the scope of the request in the subpoena, counsel for Popcorn Planet said, "I don't have a problem with the scope," and affirmed that his only concern was with privilege. Second, although the undue burden analysis under Rule 45 considers whether the materials are available from another, more convenient source, nothing in Rule 45 requires a party to exhaust all other sources of information before pursuing third-party discovery. Even if required, Lively has attempted unsuccessfully to obtain the same communications from the defendants in the underlying case. Accordingly, Popcorn Planet fails to establish that the subpoena imposes an undue burden. Conclusion. Accordingly, the amended motion to quash is denied, and the initial motion to quash is denied as moot. No later than December 17th, 2025, the movement Popcorn Planet must produce all responsive material to Lively, including every item contained in Popcorn Planet's privilege log, as well as the attachments to those items. To the extent necessary and not already covered by an order in the underlying action, the parties may propose a stipulated protective order governing the handling of this information. Okay, so there we go. Again, like I say, I'm not going to kind of weigh in on it. But I do. If Andy does appeal this, then I wish him all the best and hope it's successful. This is very disappointing, but there's not much that I can say about that. Okay, so we have a quick letter motion from Lively. I'll do this one quickly before we get to New York Times. Okay. Let's have a look. So, this is a motion to compel. On behalf of plaintiff Blake Lively, we respectfully submit this letter pursuant to Rules 1C and 4C of Your Honour's individual practices and in accordance with the Court's November 19th order to address outstanding deficiencies identified in the Wayfarer Studios, etc., all the parties, fourth amended privilege log. After 3 months and 5 opportunities to cure obvious privilege issues, the Wayfarer defendants still are withholding documents and communications that on their face fail to demonstrate a cognizable basis for asserting any form of privilege. I'm just going to make this a bit bigger. There we go. Accordingly, Miss Lively herein seeks an order compelling the Wayfarer defendants to 1. Produce those 8 signal communications, redacted. 2. Produce the redacted 2 signal communications as identified in Appendix B. The appendixes, by the way, are sealed. 3. Produce those redacted as identified in Appendix C. And 4. Produce those 10 signal communications that still concern redacted as identified in Appendix D. Shameless plug here, but I have a t-shirt in my merch store, which was pitched to me by the lovely Sarah. And that is basically, it's called Redacted. It's available in dark colors with light text, or light colors with dark text. But yeah, have a look, check it out. But I'm doing reading so much of this violence, and I feel like I'm saying redacted so much. And someone said to me, "You should put that on a t-shirt." And I was like, "That's a great idea." So, yeah, please do check that out. Okay, there is a footnote at the outset. Miss Lively notes that several entries at issue include references to redacted. Based on the court's prior decisions on this issue, Miss Lively does not seek to compel the disclosure of this information, which can be redacted if the Wayfarer defendants are ordered to produce these documents. Based on previous decisions, I'm Lively saying I'm not seeking to compel them, but if you wish to compel them, Wayfarer can just redact them. Right. 1. Wayfarer defendants should be ordered to produce all of those redacted. As demonstrated in Appendix A, none of these communications include the presence of counsel or law clerks, nor do any of these entries identify for whom the underlying work was being performed. My voice is already starting to go. Worse yet, these communications feature the very same deficiencies this court previously warned would be inadequate. Among other things, these entries fail to demonstrate that these communications are intended to give professional advice to those who can act on it, or to provide information to the lawyer to enable him to give sound and informed advice. Rather than reflect the conveyance of professional advice from counsel, many of these communications appear to reflect redacted, which is not privileged. What's more, these entries reflect more of the same conclusory claims, i.e., redacted and redacted, that are not tied to specific legal issues which this court previously warned were insufficient. Instead, redacted. 2. The Wayfarer defendant should be ordered to produce redacted. Despite previously agreeing to produce non-privileged attachments, the Fourth Amended Privilege Log confirms that the Wayfarer defendants continue to withhold redacted. As to the documents themselves, the Wayfarer defendants only offer the following descriptions: 1. Redacted. 2. Redacted. Or 3. Redacted. I feel ridiculous reading this. Oh, I do feel daft. But, it is what it is. I can't read something that's redacted. Among other things, the Fourth Amended Privilege Log fails to identify 1. The date the document was prepared, 2. The person or persons who prepared the document, 3. The person to whom the document was directed, 4. For whom the document was prepared, or even 5. How each element of the privilege is met as to that defendant. Because the Wayfarer defendants have failed to demonstrate that these attachments carry any of the hallmarks of a privileged document, they must be produced. 3. The Wayfarer defendants should be ordered to produce redacted. As reflected in Appendix C, the Wayfarer defendants continue to withhold redacted, i.e., redacted, which the court previously held were inadequate for purposes of assessing privilege assertions. Indeed, the vague descriptions provided fall woefully short of establishing that these communications fall within any form of privilege. So a couple of footnotes here. Firstly, the privilege log simply identifies a sender associated with these attachments, not the drafters of the document. And then secondly, it's worth noting that only now, in this 5th attempt at preparing a compliant privilege log, do the Wayfarer defendants indicate that they've been withholding redacted. Right, 4. The Wayfarer defendants should be ordered to produce in full, or at a minimum in redacted form, the signal communications that concern redacted. A media campaign is not a litigation strategy. This court has made clear on several occasions. In response, the Wayfarer defendants redacted. However, it nonetheless remains unclear whether the primary purpose of these communications was to discuss redacted, which is not entitled to protection from discovery, litigation, strategy, or both. Accordingly, the Wayfarer defendants should be ordered to produce these communications in their it says entirely, I think it's supposed to say entirety, or upon in-camera review in redacted form to the extent privileged content exists within these communications. And then it kind of abruptly ends there. Okay. So, there's not much to say on that either, to be honest, but, it is what it is. Okay. We now have the New York Times. And Wayfarer submitted a response to their state lawsuit last night. I have not looked at this. I don't even know how long it is. So like, okay, so it's only 6 pages long. Okay, this is not too bad. So this video is not going to be quite as long as I expected it to be. Okay. So in the case of in the Supreme Court of the state of New York, in the case of New York Times against Wayfarer, this is Wayfarer's answer. Defendant Wayfarer Studios, by and through its undersigned counsel, submits this answer to the complaint filed by plaintiff, the New York Times Company. 1. Paragraph 1 consists of legal conclusions that require no response. To the extent a response is required, Wayfarer denies the allegations in paragraph 1 and respectfully refers the court to the complaint, which speaks for itself. Do you know what? I'm going to just pull up the actual complaint so I can see what's what. But I know I've done a video on the original complaint, so I won't go through the original complaint, but I can just briefly summarize and describe the paragraphs here. Okay, so paragraph 1 is just, we're the New York Times, we're bringing an action against Wayfarer, and just references the, the Lively v. Wayfarer action. Okay, so paragraph 2, let's see what that is. It just talks about slap suits. Just says that they are used to inhibit the exercise of free speech and harass publishers by forcing them to expend time and resources on baseless litigation. So Wayfarer have responded that paragraph 2 consists of legal conclusions that require no response. To the extent a response is required, Wayfarer denies the allegations, etc. Paragraph 3, New York's anti-slap law offers redress. Again, their response to that is that it's, again, legal conclusions that require no response. To the extent that a response is required, Wayfarer denies. 4, 5, and 6. So 4, 5, and 6 are also just kind of like, oh, well, they're talking about the anti-slap and all the legal stuff surrounding that. It's not really relevant directly to as a response from Wayfarer, but Wayfarer responds similarly with, doesn't require a response. It's a legal conclusion, but if a response is required, we deny everything. 7 and 8 are about the party. 7 is New York Times is a New York corporation, publisher of the New York Times. And Wayfarer is Wayfarer, limited liability corporation under the laws of state of Delaware, principal place of business in Los Angeles. For for paragraph 7 regarding the New York Times and who they are, Wayfarer denies knowledge and information sufficient to form belief as to the truth. And then for the paragraph about Wayfarer, paragraph 8, Wayfarer admits. So that's where we are with that. And then we have jurisdiction and venue in paragraphs 9 and 10, which is basically the court. This court has jurisdiction pursuant to New York civil practice law and rules. And then paragraph 9 is the venue is proper pursuant to the CPLR, etc., because the Times' principal place of business is in New York County. So to 9 and 10, Wayfarer say that it consists of legal conclusions that require no response, but if a response is required, we deny everything. And then paragraph 10 also consists of legal conclusions that require no response. To the extent a response is required, Wayfarer denies the allegations in paragraph 10, except admits that the consolidated action was filed in the United States District Court for the Southern District of New York. Okay. The facts in the original complaint of paragraph 11 is basically, the general gist of, New York Times published a news article authored by Megan Twohey, amongst others, titled "We Can Bury Anyone Inside a Hollywood Smear Machine." And then they reference, Blake Lively, the CRD complaint, and what happened on the set. For paragraph 11, Wayfarer denies the allegations in paragraph 11, except admits that the Times published the article and the video on December 21st, 2024, and that Blake Lively filed a complaint with the California Civil Rights. In the complaint, paragraph 12 just says on December 31st, Wayfarer and its affiliates filed a suit against the Times in California for defamation and false light because of the article. Their response is that they admit the allegations. Paragraph 13 in the original complaint. On 31st of December, Lively filed a suit against Wayfarer and all the defendants there. Again, Wayfarer admit that. Paragraph 14 in the original complaint. On January 16th, Wayfarer, along with all the defendants, filed a lawsuit then against Lively, Reynolds, Sloan, Vision PR, etc. On January 30th, the action was consolidated with Lively's lawsuit. Wayfarer and its associates did not originally name the Times as a party in this case. Again, Wayfarer, in this case, denies the allegations, except admits that the action was filed on January 16th and that the action was consolidated with Lively's lawsuit and that the Times was not originally named as a party to the action. In the original complaint in paragraph 15, on 31st of January, Wayfarer and its affiliates filed an amended complaint naming the Times as a defendant. Wayfarer responds by denying the allegations, except that they admit that the amended complaint was filed on January 31st. Paragraph 16 in the original complaint. In the amended complaint, Wayfarer and its affiliates asserted 4 causes of action against the Times. Wayfarer denies the allegations and respectfully refers the court to the amended complaint, which speaks for itself. Paragraph 17. So in the original complaint, it says, first, Wayfarer and its affiliates asserted a claim for defamation against the Times for reporting that it had engaged in, permitted and or failed to prevent sexually inappropriate conduct towards Lively, and retaliated against Lively for reporting this harassment by propagating false and misleading narratives about her for the purpose of damaging her image and reputation. The amended complaint specifically challenged a single concrete statement from the Times video, which stated that Baldoni and Heath hired a crisis PR manager who orchestrated a smear campaign against Lively. So for that paragraph, Wayfarer deny the allegation and refer the court to the amended complaint, which speaks for itself. Paragraph 18. In the original complaint, it says, Wayfarer and its affiliates asserted a claim for false light against the Times. The false light claim was based on the same statement as the defamation claim. Wayfarer respond by saying they deny the allegation and respectfully refer the court to the amended complaint, which speaks for itself. Paragraph 19. In the original complaint, finally, the amended complaint asserted claims for promissory fraud and a breach of implied contract against the Times. Those claims were based on a December 20th email from the Times seeking comment from Wayfarer and its affiliates before the publication of the article. The email requested that they provide the Times with a response by noon on December 21st, 2024. The Times published the article at 11 minutes past 10 a.m. on December 21st, 2024, only after receiving comment from the attorney for Wayfarer and its affiliates. The amended complaint tried to construe the email as promising that the article would not be published before noon on December 21st. And for that paragraph, Wayfarer say that they deny the allegations in paragraph 19 and respectfully refer the court to the amended complaint, which speaks for itself. So, paragraph 20. On February 28th, the Times filed a motion to dismiss the amended complaint with prejudice. Wayfarer admits that. Paragraph 21. Following briefing on June 9th, the District Court granted the Times motion and dismissed all claims against it with prejudice. Wayfarer also admit that. Then paragraph 22. The original complaint says it's clear from the District Court's opinion that the claims against the Times lacked any basis in fact or law. Wayfarer's response is that they deny the allegations and respectfully refer the court to the opinion, which speaks for itself. Okay. There's not much more now to go. Paragraph 23. In the original complaint, primarily the District Court held that the New York law applied to the defamation and false light claims against the Times. The District Court noted that the statements emanated from New York, where the Times is located, and that decisively New York has strong policy interests in regulating the conduct of its citizens and media. Wayfarer denied the allegations in paragraph 23 and respectfully refer the court to the opinion, which speaks for itself. I'm not going to read all of paragraph 24 from the original complaint because it's really quite long actually. But they basically, to summarize, it says, well, first that the District Court dismissed the defamation claim against the Times. And they say that they were not, there's any statements from Lively were not actionable because they were based on CRD complaint and were subject to New York's fair report privilege. And separately were not plausibly made with actual malice. And then it says, as for the Times statements about smear campaign, District Court found to the extent they fell outside the privilege because they relied upon communications not included in the CRD complaint, they were not plausibly made with actual malice. They point to the judgment as well, that where Wayfarer's complaint was dismissed. Judge Lyman says that there were numerous messages and documents strongly suggesting that Wayfarer did spread negative stories about Lively, and that a reader of those messages would have little doubt that the Wayfarer party is engaged in a smear campaign. Okay, so that's right. So, paragraph 24, Wayfarer's response is they deny the allegations, refer the court to the opinion, which speaks for itself. This is a bit repetitive, but it is something that has to be done. Paragraph 25. Second, apply New York law. The District Court dismissed the false light claim because the state does not recognize this cause of action. Wayfarer say they deny the allegations and respectfully refer the court to the opinion which speaks for itself. Paragraph 26. The court dismissed promissory fraud and breach of implied contract claims, holding that they were meritless. The district court found that no contract existed and that the email at most was a promise that Wayfarer and its affiliates had until noon to provide comment on the reporting, which the lawyer did. Wayfarer say they deny the allegations and respectfully refer the court to the opinion which speaks for itself. Paragraph 27. Okay. The Times incurred not less than $150,000 in legal fees and costs for defending against the lawsuit, which had no basis in law or fact, which is impressive because all they did was file a motion to dismiss and a motion to stay discovery. That's a lot of attorneys' fees. Wayfarer's response: they deny knowledge and information sufficient to form a belief as to the truth of the allegations in paragraph 27, except denies that the amended complaint lacked a basis in law or fact. Okay. So now we get into the causes of action. I mean, there's only one. Violation of New York civil rights law. So paragraph 28 to 33. Right, 28. The Times repeats, realleges, and reincorporates the allegations in the foregoing paragraphs as though fully set forth therein. Wayfarer respond by saying they repeat and reallege the preceding paragraphs as if fully set forth herein. Paragraph 29. New York's anti-SLAPP law was an action involving public petition and participation. It was based on a news article published by the Times Communications in a public forum in connection with an issue of public interest and lawful conduct in furtherance of the exercise of the constitutional right of free speech in connection with an issue of public interest. Wayfarer's response to that is it consists of legal conclusions that require no response. To the extent a response is required, Wayfarer denies the allegations and respect. Wayfarer denied the allegations in paragraph 32. Further, they deny that compensatory damages are recoverable because the action was not commenced or continued for the sole purpose of harassing, intimidating, punishing, or otherwise maliciously inhibiting the free exercise of speech, petition, or association rights. And that's a really good point. Finally, paragraph 33. By operation of law, Wayfarer is jointly and severally liable for the damages resulting from the baseless claims brought against the Times. Wayfarer denies those allegations. Okay, so now we're going to get on to affirmative defenses, of which there are 11. So the first affirmative defense, plaintiff's cause of action is barred in whole or part because Wayfarer's amended complaint was not a slap. Second affirmative defense, the complaint fails to state a cause of action. Third affirmative defense, plaintiff's cause of action is barred in whole or in part by the doctrine of waiver. Fourth affirmative defense, plaintiff's cause of action is barred in whole or in part by the doctrine of estoppel. Fifth affirmative defense, plaintiff's cause of action is barred in whole or in part by the doctrine of unjust enrichment. Sixth affirmative defense, plaintiff's cause of action is barred in whole or in part by the doctrine of unclean hands. And I'm curious to know whether this is where Van Zandt would make an appearance, whether they would say, well, hold on a minute, you knew of or were aware of how all these communications were obtained, or whether the metadata plays a part in this. Who knows? Seventh affirmative defense. Plaintiff's cause of action is barred in whole or in part for failure to satisfy a condition precedent to commencement of this action. Eighth affirmative defense. Plaintiff's cause of action is barred in whole or in part by its failure to mitigate its damages. Ninth affirmative defense. Plaintiff's cause of action is barred in whole or in part by the First Amendment of the United States Constitution. 10th affirmative defense. If plaintiff sustained any damages as alleged in the complaint, such damages are attributable in whole or in part to conduct on part of the plaintiff, its agents, or its employees. 11th affirmative defense. Plaintiff has not incurred damages as a result of any actions, inactions, or conduct by Wayfarer. Yeah, and see, that's the point I made. Like, how are their fees so high? They had very little to do in this lawsuit. Like, you know, the amended complaint was filed. They filed off a motion to dismiss. They asked for a stay on discovery, which they got. So they didn't produce discovery during the whole time that their motion to dismiss was pending. Then they were dismissed with prejudice. I mean, what have they actually incurred? What damage has been done here? So yeah, I agree with that one. Request for relief. Wherefore, Wayfarer respectfully requests a judgment against plaintiff: 1. Dismissing the complaint with prejudice; 2. Awarding Wayfarer its costs and expenses incurred in this action; and 3. Granting Wayfarer such other and further relief as the court deems just and proper. So there we go. We are now all caught up. There's not too much to say. We'll see what happens with Popcorn Planet's subpoena, whether that gets appealed or not, how Andy is going to proceed next. I don't know. I understand from what other people have said that he intends to appeal, so that'll be interesting. The motion to compel is what it is. It's like another motion to compel, but we'll see what Lyman says. I'm sure he will grant Lively everything. This, however, it's a bit of a boring read, a bit tedious, but it's like this is necessary step. So because they've answered it, they've kind of locked the New York Times in now to this complaint. And we'll see what happens next, really. We have got coming up today, as I said at the start, Lively is due to respond to both the motion for summary judgment and the motion for judgment on the pleadings. They're going to be very, very long responses. I think Lively gets 60 pages for the motion for summary judgment to respond. So I will do separate videos, and I will probably have to do, you know, one day and one another day, because it'll be, you know, it'll be very expansive. It will take a lot of time. There probably will be attachments as well. A lot of them will probably be sealed as well. So yeah, there's a lot going on. Very, very busy. So if it feels like I'm firing off videos one after the other, I don't mean to overwhelm. But you know, I'm just trying to keep up with stuff and getting stuff out when I can. All right, guys. I will hope to be back later with one of the lively responses, but you know, because I'm in the UK, they often come down when I'm in the middle of the night for me. So I will get to them as quickly as I possibly can. Okay, so have a great day.